We've got Mark with us here from Sang, one of the top property tax experts in the country.
That's very kind.
So Mark's been here in Rotorua talking at the Property Investors Association meeting last night and gave people a really good rundown on what's happening around tax issues for property investment. So Mark, I thought I'd just start off by asking you talked about how the tax system has changed quite a lot in the last couple of years. Can you run us through that, please?
Yes, certainly. There's been a significant change in the political landscape with respect to property. There's been massive increases in value, and that's become the number one political agenda. And one of the levers that the government pulls to try and impact that is the tax system. So we've seen various changes. We've seen a strengthening of the intention provisions when you acquire a property with the introduction of the Brightline test, which is all about holding your property for more than 2 years. We've seen changes to the GST rules with the compulsory zero rating rules, changes with the LVR restrictions. It's really been a constant process. Depreciation was removed back in 2012, so you can't depreciate a building, and supposedly they don't depreciate, and that was an interesting announcement just before the Christchurch earthquake. But yeah, there's been some substantial change.
Yeah, look, so property investors actually have to be much more conscious around their tax position now, and one of the latest changes was the introduction of the Brightline test, where if you sell a property within 2 years, you will get taxed on those gains. But I understand there's some fish hooks with how that works, and what do property investors have to look out for there?
Yes, it's like everything with tax. The danger is in the detail. So the first thing to understand is how the 2 year time frame is actually measured. So you might think, oh, it's straightforward, you buy a property, you sell a property, have you kept it 2 years? But the way that count test actually works is your acquisition is measured from the last point where you became the owner of the property, where the title literally is transferred into your name, and you'll see the date on the title transfer. And that's the point where you start counting your 2 years, and that goes through to the earliest point of disposal, which is the point you actually enter your sale and purchase agreement. Not where you go unconditional, but where you simply sign up for it. So it's the last possible entry point and the earliest possible exit point. You've got to be 2 years from within that time frame.
Yeah, look, I guess that's going to catch out a few people. It's too early to see if that's happened yet.
Yeah, the law was introduced in 2015, midway through the 2015 tax year, for properties that were acquired or entered into contracts after that date. So we're still sort of seeing that starting to roll through into situations where people might be starting to look to sell, this sort of time. So yeah, it's going to become more and more relevant. It applies specifically to residential land. Mm-hmm. Residential land is defined as a land that either has a dwelling on it or is capable of taking a dwelling. Mm. There are exemptions for people's own residence, and also for farmland, but to claim a farmland exemption, the property has to be capable of being operated economically as a farm.
So a lot of those lifestyle blocks will be outside of that.
Yeah, that's right. I mean, people got a few paddocks, and a few paddocks doesn't make a farm, unfortunately. You've got to be able to actually operate it economically. So yeah, you don't get out on that exemption if you have a lifestyle block. Yeah,
and one of the other things which we're seeing a lot of at the moment is parents are helping their children buy properties, and quite often they're using trusts around that as well. What are some of the issues they have to be aware of there?
Yeah, we've got a new definition introduced to the Income Tax Act with this Brightline test, and this is the concept of the Principalset law. Now, the Principalset law definition is relevant because an exemption applies to someone's own home, but the issue is, well, how does that work if the home's in a trust? So for the exemption to work for a residence of your own, it's got to be in the trust that was set up by the principal settler of that trust. So for example, if a family decides to buy a home for one of their beneficiaries to live in, even though they would classify that as that child's home, it won't be exempt from the Brightline test because the principal settler of the trust isn't living in it. So a lot of care needed there around who is actually entitled to the exemption, and just describing the property as my home might not necessarily get you out of the test.
Yeah, so I guess that's really good information. I guess one of the other takeout points for me at the moment and listening to this is that there has been so much change. Getting decent advice is pretty important. important now.
Yeah, that's right. It's certainly with tax, it's such a moving field, and chartered accountants spend a lot of time, money, and energy staying up to date with all the legislative changes, and are well placed to advise. But certainly, people would be well advised to come and check with an expert about what their circumstances actually are before making a move.
Yeah. Hey, excellent. Thank you very much for that really good advice, Mark. Cheers.
Pleasure. Thanks, Philip.
Awesome.